I'm David Black. I'm a DUI lawyer in Phoenix, Arizona. I'm going to be talking about the broad concept of DUI today. I'm going to distinguish between what makes a regular versus extreme DUI and what makes the difference between a misdemeanor and felony DUI. And then we'll talk about what could happen if you're convicted and what our firm might be able to do to help you. So first of all, there are three classes of DUI. So there are regular DUIs, extreme DUIs, and super extreme DUIs. The regular DUIs can be proven one of two ways. They can be proven by showing that somebody is above the limit, basically in Arizona, 0.08, or being impaired to the slightest degree. An extreme is above the extreme mark, which currently is a 0.15, and a super extreme, which is actually the legal term, is a 0.20 or greater. A lot of times we get phone calls from people who think they've been charged with felony DUI because they get a super extreme DUI. There is no amount of drugs or alcohol in your system that can take a misdemeanor DUI and turn it into a felony. There are only a few specific ways that a DUI can be charged as a felony DUI. And we're going to talk about those, and we're going to refer to felony DUIs as aggravated DUIs. So extreme DUI, misdemeanor, aggravated DUI, felony. And you could get an aggravated extreme DUI, but let's not worry about that now. So common aggravated DUIs. 3 DUIs in 84 months, that's an aggravated DUI. A DUI with your license suspended, canceled, revoked, or in violation of like an interlock requirement, that's an aggravated DUI. DUI with a kid in the car, that's an aggravated DUI. And there's a fourth kind that was recently put on the books, driving the wrong way on a highway while drunk. That's an aggravated DUI. Most of these are class 4 felonies. In Arizona, there are 6 classes of felony. Class 1 is homicide, and class 6, the example I used to give was possession of marijuana. It's the least serious. So class 4 is fairly serious, facing up to 3.75 years in prison. That's most of the ag DUIs. Now, the kid in the car one is a little less serious, which is interesting because you be the judge, which is more serious, DUI with a kid in the car or getting a DUI while your license is suspended. But it's less serious. The max penalty on that is 2 years. Now, very few people on their first aggravated DUI are going to prison for a max term. But aggravated DUI has some pretty serious and unpleasant penalties. The minimum mandatory term for a class 4 felony aggravated DUI is probation with 4 months in prison. So it's kind of mind-boggling for people that they got drunk. It's their first ever DUI, but they were going the wrong way on a highway. And by the way, highway is defined as essentially a roadway. It's not what you would think of. It's not a freeway. And now they are facing a minimum of 4 months in prison. There's fines. There's a license revocation. So it's a whole, I guess, panoply of consequences. It can be pretty brutal. On the misdemeanor side, things are a little bit better. There's obviously no prison. You can't go to prison on a misdemeanor, period. And the mandatory minimum for even the most serious misdemeanor DUI for a first offense is essentially 3 days in jail with 11 days with an ankle monitor. So this one is much more serious, obviously, than this one. So what do we do? Interestingly, despite the vast difference in the consequences, the work is essentially the same. And the elements that the state has to prove are essentially the same. Was the individual impaired? Were they operating a motor vehicle? And then for aggravated DUI, you have that additional element. Was a kid in the car? Were they going the wrong way? Those sorts of things. We will try to present some options to the client so that they're not dealing with only trial versus this otherwise pretty bleak option. Truth. The misdemeanor DUIs are a lot easier to get traction on than the felony DUIs. It's just the way it is in Maricopa County right now. It has to do with politics and certain bureaus that we're dealing with. But in terms of negotiations, we're generally going to be able to put a lot more options on the table over here than over here. But there are other considerations. Has an individual been arrested before? Have they gone and gotten treatment? Did they have an alcohol problem that they've already taken care of, maybe even before they were ever charged with the crime? These are important factors. They're important mitigating factors for both the state and the city when we're negotiating with them. they move the needle less than they would in other crimes. So an example I'd give is a drug crime. You've got a drug possession case. It's your client's fourth. He's looking at prison time, but he's been to rehab, and he's really sorry, and he's sober now. Well, you're going to get a lot of love from the county attorney's office. They're probably not going to send him back to jail on that. You get a guy with his fourth felony DUI, and you have no good legal issues in that case. No matter what he's done to better himself, they're going to try to send that client to prison. You're going to have to find some good legal issues in that case in order to keep him out. Our job really is to try to find those issues, is to push the levers where we can. If there are legal issues in the case, we present them to either the city or the county, and we see if we can get a reduction in the charges, get some better options on the table. If there are mitigating factors that could assist, maybe somebody's, really turn their life around. And we have had that happen where the prosecution is willing to go from something egregious to something a little bit more reasonable, then we'll do that. That's especially true when it's a second or third offense, because the penalties are just so bad for second and third offenses that we're really able to affect some change on those. And that's true for the misdemeanors too. So I think this is a long way of saying that each of these cases is a little bit different. And the penalties vastly depend based upon what you're charged with and what your specific set of circumstances are. And we're always happy to talk to you. So please call our firm, ask to speak with any lawyer. Our number is 480-280-8028. Thank you.